Good morning, everyone, and thank you for joining us today. We have a few guests who are currently joining in, so we'll just wait for a couple of minutes before we begin the session. This is our first session of the year, and we wish you all a very happy, healthy, and prosperous new year. I think the stock market is taking care of the prosperity bit, so I hope that continues, and the year ahead is healthy and safe as well. So we'll just wait for a minute or so and begin the session. A very good morning to all of you, and thank you for joining us for the Capital League Insight series session on succession planning. Capital League Insight is our special initiative to share information that is relevant for your wealth and financial well-being. As we all know, 2020 has been a year of heightened uncertainties and anxieties, and this year has nudged us to get our act in order, to think about things and act on things that we typically postpone for the future. And estate and succession planning is one such topic that's been there on everyone's mind. Accumulation, consolidation, and distribution. These are the three pillars of wealth planning. We work very hard to accumulate our wealth or to set up a successful business. It's equally important to have a plan in place that helps with the distribution of this wealth post our life in line with our wishes and without any undue delays or hassles or any kind of family disputes or any kind of leakages in terms of taxes or duties, etc. So to know more about the nuances of estate and succession planning, we have with us today Mr. Tariq Abu Bakr, Managing Director, AmiCorp Trustees. Tariq has extensive knowledge and vast experience in the field of succession planning. He has worked for more than 15 years with families and business houses, having wealth across asset classes and geographies. He is also the recipient of the 40 Under 40 Award as a trust expert in the industry. But I would say that he is not just a trust expert, but he is recognized to be the succession planning expert in the industry. And I am so delighted to welcome him today. Thank you for joining us today, Tariq.
It's been a pleasure, Vinita. Thank you so much for having us.
So, we have a lot of questions for you today, and over the next 45 minutes, we'll go through all these questions. I know this is a very vast subject, and 45 minutes is not enough to cover it, but the idea is to have an introduction on different aspects of succession planning. Post our discussion, we will open the questions for our guests. I would request all of you to please send us your questions in the Q&A section that you can see at the bottom of your screens. During the discussion, we would also have a few opinion polls to get some quick inputs and views from our guests today. So Tariq, in our experience, as we have worked over the years with different client families, we've seen that this topic garners very different reactions from people. The one thing that is common is that, yes, everybody does realize that this is critical and needed. The other thing that is commonly seen is that typically most people postpone this, to be done at a future date. This is a sensitive subject, and there are families that are uncomfortable talking about it. And there are also families who feel that, their family structure is very small or it's uncomplicated and it doesn't really warrant a proper estate plan. So for a large number of families, the main tools of estate planning that they use are nominations and joint accounts. In fact, we have our guests with us here today. So let's just see what they have to say about this. Can we have our first opinion poll, please? I have a joint account and nominations on my investments. Do I need a will? I would request all of you present here to please respond to this on your screens, and we'll share the results just in a few seconds. Okay, so 88% of the people here feel that they do need a will. Wonderful. So I think it's a very well-informed group that we have here today. I think just recognizing that something is needed, it's also half the problem solved and half the job done. So Tariq, let's start from the very basic. Let's say someone passes away. If you could take us through the process of asset transfer. There is a nomination and joint account in place, but there is no will. How would the asset transfer happen?
Okay. I mean, it's very nice to see that 88% of the team or the clients here feel that a will is important and necessary for the benefit of them and the balance 12%. If you go by, in a very layman term, a nominee in our mind, we think that we've done a nominee in an account and he or she will become the rightful owner of the property or the asset we leave behind or the mutual fund portfolio or investment that we leave behind. And we think that we've done a great job by adding a nominee. But if you go by the technical term of a nominee is only a guardian. He or she is not the rightful owner of the asset that he has been nominated for. The role of the nominee, okay, even before we go to nominee, I'll just take a step back. Uh, how does succession really work in case if there is no will or there is no succession plan in place? It is the law, which is your religion that you're governed by. There is no state law, there is no Delhi law, there is no Maharashtra law. It is the law of your religion. So in a Hindu family, it says equal to all legal heirs. In a Muslim family, it will be two-third, one-third, which means that the male member will get twice of what the female member will get. And of course, then there are a lot of other hierarchies in that. Again, in a Christian and Parsi family, it is equal to all legal heirs. So this term equal creates a lot of complications. What do you mean by equal? You've got one house. Um, you have two children. You expect both the children to start living in that one house. You expect one to pay rent to the other. You expect them to sell the house and give the proceeds to each other. So the term equal creates a lot of complication. So again, the same way, if you have a nominee and you have said that this person is in your mind, a nominee is the rightful owner. But the actual role of the nominee is to pool in all the assets and distribute it as per either natural succession in this case, which is equal to all legal heirs. So just by doing up a nominee, you've really not solved the problem, you've created more complications because then it will be equally distributed and term equal is very subjective. That's one. Two is that bank accounts. We think that we have a joint bank account with our spouse or with our children. Again, having a joint bank account is only for ease of operation. If you have a joint account and either of the joint account holder is deceased and you go to the bank and submit the death certificate, the account will be frozen. You will not be able to operate an account of a deceased. So again, having a joint account is not a right way to plan your succession or a ease of management after demise. It is while during the lifetime only. It is not after demise. So these small myths that most of us carry, that I've done nominees, so I'm taken care. I've done joint accounts, so I'm taken care. That's really where we go wrong most of the time.
Okay, yeah. But yeah, fair enough. And yes, a lot of people do think like that. So that's one part that, okay, so, over and above nomination and joint accounts, we've got to have some other, whether it is a will or any other form of estate plan in place. Now, we all know that estate and succession planning, it's a very vast subject, and there is more to it than just disposition of assets post death. So, what all does it entail, and what are the factors that one needs to keep in mind while starting the process?
Again, if you use the term succession planning, the English definition of it is succession, which means passing on. But if you holistically take it, estate and succession planning, it is your estate during your lifetime. So utilizing your wealth to the fullest and then talking it about passing it on to the next generation. But most of the time, when you talk about this to a client, the common things are, oh, what's the need of it? It's too early for me. I'm only so much. I'm just too young. We're not talking about death here. We're not talking about leaving your legacy behind. We're talking about managing your legacy, protecting it for the interest of yourself first, and making it easy for you to plan your succession by holding it in the right manner or in the right way from day zero. So there is no right age for planning your succession. Okay. The moment you have assets that you are going to be leaving behind, you need to have a succession plan in place. What tools you use for succession could vary depending on many factors. One could be where your beneficiaries are. So if they're living overseas, then taking into consideration the laws of the country that they're living in, US, UK. If they're living in another country, so how they're going to inherit the asset becomes very important. Also, what kind of assets will they inherit? Will it be solid assets like immovable properties? Will it be movable properties? Will it be agricultural land? Will it just be a plot? So, what kind of assets they're going to inherit also will depend on how they should inherit. Because US doesn't recognize agricultural land. If you have an HUF, US doesn't again recognize HUF. So, depending on the asset classes, again, your tools for succession can be defined. So there are three broad tools of succession, or I would say four. One is you could simply gift it during your lifetime. Two is do nothing. Succession will still happen, but obviously complications arise with it. Three is you do up a will, and four is you get a more sophisticated way of managing it by a family trust. So these are the more common routes for succession. A trust is a living body that runs parallelly with you. It helps you to benefit out of your assets during your lifetime, and it goes in the most smoothest and effective manner for the benefit of the beneficiaries. Whereas a will is a static document, it comes purely in demise of an individual. It needs to be executed, and that's where the problems really arise.
So, there are these multiple tools of estate planning, and we know that each family's situation is unique, and based on the circumstances, based on the requirements, they would select solutions that would be most appropriate for their unique situation. So, let's start a little in detail from on each of these tools, and let's start with the will, which is the most traditional, common, and popular mode of estate planning. What are the ways in which one can write an effective will, or rather, how does one make a will most effective, avoiding the mistakes people do while writing the will? And what are the scenarios in which a will is most beneficial or useful?
Okay, Vinita, your voice was a little muffling, but I think I got your question. A
You
will,
want me to repeat?
if it's wrong, then you could correct me.
Yeah, should I repeat the question? I said, how can we make the will effective? And what are the common mistakes that we can avoid? And what are the situations in which will is most useful?
Okay, so a will is a static document which purely comes in the demise of an individual. You can make as many number of wills during your lifetime. Your last will is considered as the final will. The common areas. Okay, now there are different questions that come up during this process always. If I have a handwritten will, so what? Do I need to have a computerized will? Does it need to be in English only? So all of this is not required. A handwritten will is as good as a computerized will. It's as good as a printout. A will written in regional language is as good as a will written in English. So there are no limitations. But the will should primarily comprise of your wishes and at least be witnessed by two people who are preferably not the beneficiaries. So to make the will authentic, it needs to be at least witnessed by two people, and those two people should not be the beneficiaries. Then, if you are a senior citizen and you are making a will, it is good to be supported by a doctor's certificate that states that you are of sound mind, because these are loose grounds of contest. Okay, now the will was written under pressure, the will was written under alcohol influence, or the will was written under at the time when the person was not sound of mind, and those kind of issues are very loose ground of contest. And by having a doctor certificate, you take care of that. Again, a will should be very precise and to the point. Like I have read wills which run into 20 and 21 pages. I gave the best upbringing to my family. I love my children. All that is not really required to be a part of the will, because the will should be precise to the point and should not be able. You should not be able to interpret it in any way. It should be interpreted only in one way, regardless of who reads it.
There shouldn't be any ambiguity, you're saying.
Yes, there should be no ambiguity, and it should be precise to the point. You don't need to write your. You can always write a thank you note to your family separate. It need not be a part of your will. Two is that people have gone ahead and chosen executors. So executor is a very important person after your demise, because he's the one who's going to go around running around executing your estate. And most of the time, people choose friends and family. It's very common. I mean, none of us here will have a friend who's 30 years younger than us. I mean, a very good friend will be 2 years younger than us or 2 years elder than us. And that's the one we commonly choose to act as an executor. And that's a very common mistake, because he's the one you believe in. But you are 75, he's 78. Or you are 80, he's 82. I mean, you don't expect him to do the running around at 82 here. He may not be able to do justice. So identifying a right executor, maybe identifying a corporate executor, maybe identifying a younger generation person executor, uh, should be the way it is. People also go ahead and do organ donation in a will. I would like to donate my organs, this, that. I mean, again, there is a way of doing organ donation. A will is not an instrument where you need to write your organ donation, because I have not come across a family yet in the last 15 years where someone has heard someone passed away and the first reaction is, where is the will? It doesn't happen that way. A will comes out maybe 1 month later, maybe 2 months later, maybe 6 months later, whenever the family is prepared to now look at other things apart from the loss in the family. And at that time, you realize that they couldn't fulfill your last wishes because your last wish was something else. And then you leave your family with a very heavy heart. So those are not things that need to be part of the will. So appointing a right executor, making it as simple as possible, precise, to the point, without any interpretation to be dealt in any other manner, witnessing it, and uh, if supported by a doctor certificate, depending on your age group, preferably registered. It is not mandatory to register a will, but any registered document holds a lot more weightage than an unregistered document, because then the basic ground of contest, saying that alcohol influence, not sound of mind, under pressure, all those basic ground of contest gets taken care, because then the registrar himself is a witness, directly or indirectly. So a registered will is always good. You can make as many number of wills, but the last will is considered as your final will. So if you have made a will earlier, and so maybe in 99 you made a will and you got it registered. In 2020, when you make another will, either you give a reference of your existing will that you have a registered will and this will supersedes that, or you get this will registered on top of that with the same registered ID. Or if you do not want to register this, you cancel that will. But at any point of time, there should not be multiple originals floating around. At the same time, Vinita, this is something where you may be able to add a lot of value to the clients. Having your nominee or having your beneficiary of the will, preferably the same person. So I bought an insurance policy way back in 95, in which I put my nominee as my wife. But now I have one son and I'm making a will and I'm saying that the beneficiary of the insurance policy will be my son. Okay, so you need to clean up and try and keep your nominees and your beneficiaries the same so that there is no dispute again. In places you put in your elder son as a nominee, in the will you put in your younger son as a beneficiary. So you need to do a cleanup exercise for the clients and make sure that the nominee and the beneficiaries are the same and not different people. So like that, it is a, uh, at the same time, you have to have your thought clear. Okay, if you're giving one asset to somebody, then you may want to write a little more in terms of how they want to execute that asset. That they have the rights to sell, they have the rights to liquidate and give the money to each other, and those kind of things you could express. Um, there's
And you
one more.
said that, if somebody has one house, that they are willing to two children,
Yeah.
what happens to that house, and, if
So
they
you
have
could give
different
that one son
requirements.
has the right to buy out the other.
Hmm.
You could also put in some amount of time frames that if he wants to buy out, he should buy out within the first 6 months, or it is available to sell in the open market. Otherwise, okay, I'm buying, and I keep dragging it. I never buy. So those kind of directions can be given. Again, a very common mistake that people do is I'm willing this to my wife, and after my wife, it should go to my son. Okay, a will is not a multi-layer uh, instrument. It is only to the first level. So I have willed it to my wife. Now it goes as per my wife's will. So I cannot control that after me what my wife will do with those assets. I can only give it to one person. So writing in that I'm giving it to my wife and after my wife it should go to my son is not something that you can legally enforce. It is either you can request your wife or it will go as per her will. So if she wishes to give it to her brother, she has all the rights to do. Again, there are two broad categories of assets. I mean, as a wealth team, when you look at it, you look at movable and immovable. But as a succession planning area, we look at it as self-acquired and inherited. Okay, so what I can do with my inherited assets and what I can do with my self-acquired assets are also different. If I have inherited assets from my ancestors in form of a will, it is free for me to will further. But if I have inherited assets from my ancestors intestate, which means without a will, then I do not have the rights to will it to the person I want. It has to go equal to all legal heirs. So very important, even if you say that I have only one son, why do I need a will? Okay. Yes, it is supposed to go to him, but give it to him in form of a will at least, so that he has the rights to dispose it further to two children, amongst two children, to one of a charity or whatever, and it doesn't become a part of his inherited assets. So very important to give the son or your daughter the flexibility to do what she wants with or he wants with that asset by just simply willing it to them.
Right, that's a very valid point. So, but Tariq, you've seen that despite best of efforts and having clear wills and everything, wills are often contested and there are issues around it. So, how does one address those issues?
So something that needs to be executed after I'm not there is always open for interpretation. And that's where confusion starts. So if these small things, if you take care by having a doctor's certificate, by drafting the will simple and not making it too complicated, getting it witnessed by the right set of people, preferably getting it registered, will take care of most of the issues of contest. Can it still be contested? Yes, it can be contested. However well drafted a will it is, whoever has drafted it, whatever English language you use, can it be contested? It can be contested. But these things will at least make sure that the judgment goes in your favor. So to avoid, if you're foreseeing any amount of contest happening within the family, or if you're foreseeing those kind of issues, in that case, you rather use another tool for succession, which is a trust. So there are two broad categories of a trust: a revocable trust and an irrevocable trust. A revocable trust is as good as a will. Okay, whereas a will comes in play on the demise of an individual, a revocable trust is something that runs parallelly with you for yourself during your lifetime. The fundamental difference between a trust and a will: in a will, assets change hands. So it goes from me to my children. Whereas in a trust, the assets always remain in a trust. Earlier, I was the beneficiary, now my son is the beneficiary. So the assets don't change hands, the underlying beneficiaries change. Due to which the scope of contest is zero, because I have seen this trust during my lifetime. I have set it up during my lifetime, and for which the area of contest is zero. At the same time, it also takes care of my old age and retirement. So my money utilized for myself, because a will again will come in play on your demise. But during my lifetime, if I'm hospitalized, if I'm unable to contract, if I am medically unfit, at least my trust will take care of me. My money will be utilized for myself. A trust is also very good for minor children, because while you write a will, a minor cannot inherit the assets. Then uncle, auntie, chacha, chachi, all these becoming guardians and trying to make good out of it and turns out to make it a mess. So then if I have minor children, it is always good to do a trust. If I have son, daughter who are in a marriageable age, it is always good to give them assets through a trust, so that you know that in case of a marital dispute, the in-laws or the uh, son-in-law or daughter-in-law cannot claim on these assets. I have seen a lot of families where, like in the Marwadi family, they call it the file. मैंने मेरी बेटी के लिए फाइल बनाया है, ये शादी पे उनको दे देंगे. So I've seen situations where 100 crore file has been passed on to the in-laws at the time of marriage, and 6 months down the line, the lady had a divorce. She came back. Where that 100 CR went, no idea. So those kind of
Right.
things do happen. So whatever you want to gift your children during the wedding, whatever you want to gift your children, you rather give it to them in a trust. At least you are sure that that money will get not stifled off by the uh, son-in-law, daughter-in-law, in-laws, whatever it is, and it will go to her or his children instead of it going to the spouse. Because then you can
Right.
choose who the successors are. Even when you're willing it to your wife, and you have this thing in your mind that after my wife, it should go to my son, which you can't control in a will, you can do it in a trust. So a trust is a much sophisticated tool to use and the best mode of succession as of today. Then, of course, these are revocable. There are other reasons where you set up an irrevocable trust for. So, if I'm into business, I'm acting as a director in many cases. Liabilities are haunting me, and I want to
So I
ring
think
fence.
we can, trust can actually be used in many such
Yes.
instances. We can take up individual examples of such scenarios and it would become even more clear to everyone who's listening in. So basically, what you're saying is that while will would be a good solution to a lot of families, but for a lot of other families with certain situations, will can probably be used in a combination along with certain other solutions like a trust along with a will or something like that.
Absolutely.
At this moment, let's just take a moment and see what our guests today have to think about trusts. So let's have our next opinion poll, please. Do you think trust is complicated and meant for more complex situations? I would request all of you to please respond on this. And while we are waiting for the results, I would like to remind all of you that we would be taking some questions from all of you. So please keep sending us your questions in the Q&A section that you can see at the bottom of your screens. Okay, so let's see what the result looks like. So we have 77% of the guests today who believe that trusts are more complicated and meant for more complex situations. Right, and this is the common perception, Tariq. Can
I'm
you
not
just
surprised.
remove the results, please, from the screen? This is a common perception that a large number of people do find it hard and complicated. And, it's like the common thing is that trust is not for me, but for more complicated things. So, how would you address this concern?
Okay. When I was young and I used to see my dad drive, I used to always wonder that how can you manage? I mean, should I look in the front? Should I look at the rearview mirror? Should I brake, clutch, accelerator, gears? I mean, what do I do? How can I do so many things at one time? And driving seemed the most complicated thing to me as a child. But today, when we are driving, we are munching, we are talking to people sitting around us in the car, we are even talking on the phone. At times, I see people even texting while driving. So, till the time you don't use it, you will always find it as a different species of animal that is probably not meant for you. Okay, I'm so glad to see this review of 77% people uh, thinking it's complicated, because that gives me an opportunity to address 77% people that it's not complicated. Because if you and me agree on something, the call can end today. But if I have an opportunity to explain you what is the difference, then that's the value add I'm bringing to the table. Okay. So, like driving, till the time I did not start driving, I found it very complicated. But the same way, if I have not used a trust, I am going to find it complicated, and which is fair. Uh, so the question goes to these 77% people that in case of a minor child, what do you do? Husband, wife are traveling together, God forbid something happens. The child cannot inherit the asset because he's a minor. Then how do you leave the legacy behind? It is not that the legacy will get worn off or stifled away or something, but it will create complications because the child cannot inherit. The same way, in case if you have a special child need, then what do you do? How do you take care of that special child in your absence? In case you have children living overseas, then what do you do? So, whereas a trust is, as if you have done an HUF in the past, a trust is nothing but a most sophisticated manner of an HUF. The fundamental difference between a trust and an HUF, or HUF is a predefined rule, and you are molding yourself as per the need of an HUF or the rules of an HUF. Whereas the trust is like water, you're customizing it to meet your needs. It is nothing if you have set up a private limited company and you're doing business in that, you've created a separate body to do certain activities. And a trust is exactly that. You've just created a separate body to do certain activities. And those certain activities are managing your assets, holding it for yourself during your lifetime, and talking of your succession eventually. So there is no great thing that we are really trying to educate here. Then people come into areas of relinquishment of ownership and control. That if I move my assets into a trust, will I lose control on those assets? Will I not be able to do what I want to do? Today I'm as free as what I want to do. Those are again very bad notions. By moving assets into a trust, you do not relinquish control. You can manage and control your trust assets as simple as you would have had they been in your individual name. A lot of people who have heard about trust have always heard about charitable trust, okay, where the donor and the donee do not know each other. So I do not know what's in my interest, due to which the middleman, which is managing the trust, has room to decide how to spend that asset. So you may have given donation into a trust to build a hospital, but suddenly there are floods in Ahmedabad, and the manager decides to move that money to Ahmedabad to take care of the floods. So because the underlying do not know what is in their interest, they cannot demand for it. But in a family trust, that is not the case. The settler settling assets, which is the patriarch of the family, for the benefit of the family members, they very well know what their rights are. They very well know what is coming to them. They very well know what is it. So the whole notion of trust money getting stifled away and all, there was room to do in a charitable trust, but not in a family trust. So please do not compare a family trust with a charitable trust. They are completely different tools with the same extension trust, but there is no comparison between that. A trust is more for continuity of family. So, say, giving an example, you have a company who's ultimately going to go to your son, but at the same time, you want some income from that company to go to your daughter, but you do not want to give ownership to your daughter because then you feel ownership will go outside the family. How do you do this? I mean, you will expect the son to keep giving money to her every year. You're again creating personal obligations, which are not legally enforceable. So, depending on objectives and need of the family, trust is important, or identifying the right tool is important. In case of a asset protection, say you, God forbid, get into a litigation sometime in the future, all your assets which are in your individual name, whether you willed it, written in the will, whatever you've done, can get attached. And you may have nothing left in the hand to will it also. But if you have created a structure like a trust, you could be able to protect most of your assets. Of course, there are rules to the game, but
Tariq, just to interrupt here before we move to asset protection, like you're saying that trust is more relevant to situations that are more unique. So let's say a family has a special child. There are a lot of families also who are single men or women with no successors. And often in those cases, wills are contested. And it is sad to see that the hard-earned money and assets that they have built after their life are just lying disputed and nothing really happens to them. There are also families of elderly couples with children overseas, and these families, these children find it very cumbersome to manage the whole process of transfer of assets. And so basically you're saying that in all these situations that are a little more unique, so to say, trust would be more useful, and it could be simplified so that it doesn't really it doesn't have to have various holdings and all that. It can be simplified to suit the needs of each family and protect the assets and ensure a smooth transfer.
absolutely, very
So
rightly said.
so we will move on to the asset protection bit as well. But before that, we have a lovely audience today, and it's really nice to get their views. So we'll have a last opinion poll with them. Can we have a next opinion poll, please? Do you worry that your business actions could create liabilities and impact your personal wealth? May we have your response to this, please?
This could also be where you are only a director in a company, because the director liability is
Yeah.
also very high. not necessarily that you are leveraged.
Yes. Just wait for a few seconds more. Okay, so yes, we do have 63% of our guests today who feel they are worried about impact on their personal wealth. And this takes us to our another objective of which is part of succession planning besides wealth transfer. Whether you're a CEO or a entrepreneur, you are taking decisions in your daily business life which could create liabilities and impact your personal wealth. So how does one safeguard against this eventuality?
Okay, so something that is owned by me is very easily attachable if something goes wrong at my level. Proving that the income derived from those companies has been used to buy these assets is very easily established. Then what do I do? I start buying wealth on my wife's name. I start buying wealth on my children's name. Um, how it plans out, I don't know. Because what if I need those money back in the future? How will I manage it? If you see, we're not trying to promote something which is not tried and tested legacy. If you go down to any of the large Gujarati and Marwadi families, you will see 99% of the families, the house is in the name of the lady. Okay, and that's a legacy tried and tested tool. Why? Because the guy is going out doing business, taking risk, gambling, sometimes getting into alcohol, and he may risk uh, the family home, due to which the family home is always in the name of the lady. But as time changes and generations switch happens, the number of divorce cases have increased tremendously. Now, in this case, is it as safe to keep the family home in the name of the spouse? Maybe, maybe not. So then what do I do? Should I gift it to my children? Do you want to deal with another Singhania kind of matter where children are now not valuing you and not respecting you and not giving you access to your own asset? So then it becomes a middle path, a trust. A trust is a living body that runs parallelly with you. It owns your assets and holds your assets for the benefit of yourself and your family members. So if you're looking at asset protection, you rather move assets into the trust for the benefit of the family members who could be beneficiaries, not yourself, because there has to be an irrevocable structure. And the same beneficiaries could derive full benefits out of it since it is not owned by you anymore. It is not deemed for any kind of attachments. But obviously, the Insolvency Act arises here, where there is a 2 year cooling off period. So if I do something now and within 3 months I decide to declare bankruptcy, it is very easy for the law to establish that I did this out of sure planning. I was foreseeing this coming, due to which I set up a trust. But if I set up a trust today and I move my assets into the trust by making my wife and children the beneficiary, I can still control those assets by wearing a different hat now. And 3 years down the line, something goes wrong. The law cannot attach these assets. So I rather have these assets utilized by my family for my family than get it linked to one of the litigation outside and the money getting totally wiped out. So these become very important ways of managing your wealth during your lifetime. I'm not again talking about death here. All of this is for you during your lifetime. And then looking at it and how it will go further. Now, currently in India, there are no inheritance taxes or estate duties as they call it. But in development countries like US and UK, there are inheritance taxes. And trust and all is a very common tool to use. But the way the law is moving out now in India, there is a lot of speculative information floating around. And I use the word speculative that estate duties could get reintroduced in India. This could happen, that could happen. Now with the new COVID situation, I don't know if that is really a story anymore. But there have been a lot of instances where people have set up trusts with the fear of estate duties reintroducing in India. I would say you plan your succession, keeping in mind multiple factors, estate duty being the last, because we do not know whether it is coming or not. We do not know if it is coming, how it is coming. What will be calculated in that, what will be considered as that, what will not be considered. Something that you have no clue about. How can you plan something for? You can take approximate ideas. Okay, internationally it happens this way, so this will get replicated. Okay, in India, earlier estate duties were there in this manner, so the same may get replicated. You could take reference points from there, but you could not confirm and say that it will happen this way only, because one, we don't even know whether it will happen or not. So let's not run towards things that we don't know, but at least protect ourselves from the things that we are mindfully aware of, and plan your life going forward in a more sophisticated manner, in a more easy way of managing the assets, whatever the situation may be, and taking full benefit of your assets during your lifetime, and not worrying how it goes to the next generation because you have planned it in a best possible tools available today.
Right. That's very relevant. So that brings us to our last question before we take questions from our guests. Something equally important, we've talked about personal wealth transfers. We'll now move on to business families. There are business families where the next generation is also involved in the business. In certain cases, they are not. We also have instances where, let's say, there are two children and one of them is involved in the business and the other is pursuing other interests. So, in such a scenario, how does the head of the family, plan for the succession such that the business also continues to grow successfully, and more importantly, there are no disputes amongst the family members as they go along? So, what kind of solutions should they plan?
I mean, this is a very common uh, problem with business families. I have two sons. The elder son joined the business much earlier because of him finishing his education earlier. The younger one still studying. So the elder one thinks when he joined the company was at X. Because of his hard work, because of his efforts, the company now become 3X. So he should get a more bigger pie in the company because he's already put in his sweat in the company. The younger one joins the company at a 3X level. And then they both split the company equal. So the elder one always feels that it is unfair to do equal. Um, at times, what happens is that the elder one is running the company, the younger one is doing something else, who's been funded by the parent company. And he owns 100% of that company because he started that on his name. Whereas the parent company is still owned by the father. And both the sons have 50-50% stake in the company legally. So then the younger one has got a 50% stake in the parent company and 100% stake of the new company that is he set up for, where he's not even adding any value in the existing company. So that is where a lot of disappointments sink in. So having clarity in terms of how the inheritance will happen, who will be the next CEO of the company. So there are two pain areas: money and power. These are the two very big pain areas. So I want to dictate terms in my company because I've been running it all along and it's mine. Whereas the other one says that it is the father's business, and I also want to take a controlling stake in there. Then there's also fear of one who's not been in the business liquidating his shares outside, and the company becomes a little more global than a family business now. So how you control those things? Obviously, your memorandum article does say right of refusal to purchase the shares is first lies with the existing shareholders. So those kind of checks and balances are already in place. But how do you holistically control? Then one of the examples that I used earlier, where I have a daughter and I want to give her certain benefits from my family business. but I still do not want to give her shares because I don't want the shares to go outside the family and I want the controlling stake to be with my son, for example. So a lot of these instances are there because of which, if you see back history, none of the Indian large businesses have been able to survive more than 3 generations. Everyone's broken into pieces and been pushed back to a smaller unit because of family disputes. Otherwise, the Indian businesses would have been much, much larger and on a bigger scale on the global chart. But these are instances which are very specific in nature, and there is no one answer to it. So we can, of course, sit together and analyze the situation. We can
Yeah.
also pay attention to the wishes of the family, which are very unique in nature, and then offer a solution. Because see, as a wish, a lot of times families have a wish because there's family, because there is affection, there is bonding, there is relationship involved. But legally, those wishes, how to implement them, is where our expertise come in. Because I may have any obscene amount of wishes, but how do I legally enforce those wishes is where the expertise role plays.
Sure.
So to
So solutions are present, and depending on each family's requirements, we could discuss those in detail, and each family could plan it accordingly. So, Tariq, we have lots of questions here, and one common question that I see over here is based on taxation of the trust. So, if you could just talk on that.
you know, I always get this smoky smile when I hear about taxes because for some reason we've always been so engrossed in how much percent I am saving because of my taxes that we a lot of time miss the big picture. Uh, how do I save my taxes? How do I do tax arbitration or how do I do tax planning? And we spend so much of our energies around that. But coming to our main subject, a trust is as good as an individual. A trust does not pay any amount of high taxes. So if you choose a revocable trust, the assets of the trust are considered as assets of the settler, tax in the hands of the settler. If you choose a irrevocable trust, a discretionary trust, assets of the trust are considered as assets of the trust, tax in the hands of the trust, and then distributed. If you choose a determinate trust where the shares of the beneficiary are defined, it is taxed in the hands of the beneficiary. So at any point of time, your taxes are at par with an individual. In the income tax filing, also, there is no category of separate taxes for the trust. It is as level of an individual and not at the level of a corporate. So there is no tax leakage or tax loss or extra taxes that you would have to pay by moving your wealth and planning your wealth through a trust. Existing assets that you have, those can also be moved into the trust without any stamp duty implications, without any long term, short term sale considerations. There is no tax implications even on that end. And existing assets can also be moved to the trust. Now, if you have mutual funds, shares, and stocks, all of those can move to the trust very easily without any stamp duty, without any long term, short term, nothing. Company shares can be moved to the trust very easily. No stamp duty, no implication, no nothing. Real estate held in individual name can also be moved to the trust, but there will be a stamp duty implication there because there is a change of ownership that happens. So the property needs to be re-registered in the name of the trust, due to which there will be a stamp duty implication, but no taxes again.
Right. So, the other question that we have, and this is commonly asked, is that can a husband have a combined will, if the successors are the same for both of them?
See, a joint will is very strongly recommended not to do because once the will is executed, then executing a partially executed will is very complicated. So, not necessarily that the husband and wife will hit the bucket together. So, one is deceased and the other is still there. And any which way, you have a right to write another will. So by doing a joint will, what are you trying to establish? Nothing. Because after the demise of one, the will anyway need to be changed because now my shares of assets are different. So earlier I wrote that I have 50% wealth in this particular company. I have 50% shares of the house. I have 50% shares of this. Now that 50% of mine has become 100% because I've inherited everything from my spouse. So anyway, you need to redo another will. So a joint will is zero value add. It is better to have a independent will of two people because even from an execution point of view, executing a partially executed will leads to a lot of confusion.
Right. Okay. Our next question is, does a family settlement need to be amended every time some asset is encashed or sold? Does it have to be registered with authorities? And which is the preferred mode between a will and a family settlement?
Both are different objective driven tools. A family settlement is between larger families, brothers, cousins, uh, and the need of a family settlement is different from a need of a will. So I have ancestral property which is jointly held between brothers, and now I want to split that and give clarity to who owns what, who's where, and create an independent lifestyles for everybody. That's when I will do a family settlement. It needs to be registered. It need not be amended every time because the settlement once done. It needs to be executed now. But a will is something where I'm transferring my ownership of assets into the name of somebody else. So both are two independent instruments used for two independent objectives. No comparison.
Fine.
Just one
Okay, so we
thing is that when
sure.
people own real estate also, and they have this myth that I and my wife own real estate. After me, my wife has become the independent owner of the full real estate, which is totally wrong. Because after you, your 50% is needed for succession. So your 50% will either go as per your will to whoever you will it to, maybe 100% of your 50% to your wife, or maybe to your children. But if you don't document that, the surviving heir who's owning 50% of the property does not become 100% owner. So that is what people have done. They bought a house jointly with their son. They bought a house jointly with their daughter, thinking that after me it will go to her, after me it is for her. But that will not happen because if you bought a house with your son, uh, with the value not increased, and you bought a house with your daughter, where the value has gone multifold. In your mind, it has been bought jointly with your daughter because it is for your daughter. But legally, your son can take 50% stake of your 50% because that
Value
is
is higher.
that is due for your succession. The surviving heir doesn't by default become the rightful owner of the property. So
Mhm.
that is where we have tried to be extra creative by thinking we have planned a succession by not using the right advice or right tools, and that is where family disputes very prominently crop up.
So, on a similar note, we have a question which says, if you phrase on my demise to my wife, and should she predecease me, then equally to my two children, would this automatically go to the children who are both major in case both of us die in, let's say, an air crash?
Yes. So if you have written in your will that if you do a well drafted will, all of these things will already be incorporated there. That I wish to give 100% of my wealth to my wife. In case my wife predeceases me, it will go to my children in this particular manner. So predecease or decease at the same time is the same. She's not there at the time of executing of the will, which means that the tier 2 beneficiaries trigger in, and you can always write in there. So if a well drafted will have all these points captured. That in case if something happens to her before me, or if in case something happens to her with along with me, then what to do will be captured in the will.
Okay. Thanks, Tariq. That is extremely helpful. We still have a lot of questions that are unanswered, but unfortunately, we've run out of time. We will make a note of these questions, and wherever we have the contact details available, we will revert to you with individually. Thanks a lot, Tariq. This was extremely informative and insightful. And I do hope that everyone who attended the session today got some takeaways for your own unique situations. I'm sure you would need details. I mean, this needs to be discussed in details, which can then be taken on a one-on-one basis. So thanks a lot. A big thank you to all of you for joining us, for participating with us today. And just one last thing, as you sign off from this webinar, there will be a small feedback survey that will come on your browser. I would request you to please take a few seconds to fill up that feedback survey. It would really help us to make our upcoming sessions more insightful for you. So thanks a lot and have a happy weekend.
Thank you so much, everybody, for giving us this opportunity and being with us on a Saturday morning. Thanks, Vinita and team.
Thank you very much. Yeah, bye-bye.